Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to all, especially to Mami and my learned fellow friends. I hope everyone is in a good health. Amin, inshallah. Okay, on this peaceful morning, my friends and I would like to share on a case review, namely AK and NZB 2020 Volume 2 Syariah Law Report, page 1. This case specifically discusses on the issue of Hadhanah of an infant. Therefore, we will review this particular case from the aspect of substantive and also procedural laws. All right. Okay, let us begin the presentation with firstly reviewing on the facts of the case. Okay, in this case, it is good to be noted that the plaintiff is the father who is a non-Malaysian citizen because he is a Nigerian and he only rely on a visa to stay in Malaysia. And the defendant, who is the mother, she is a Malaysian citizen in this particular case. Okay, to further, the plaintiff and the defendants were married and eventually had divorced by way of fasah in Syariah Lower Court of Gombak Timur on 30th of March 2019. Both of them have a child during their marriage who was still under the age of Mumayyiz, which the child was 6 years old. Okay. The plaintiff eventually claimed that since he was divorced with the defendant, the child had lived with the defendant, which is the child's mother, and the plaintiff was denied the right of the plaintiff to meet and be with the child for a period exceeding 3 months. However, in the defense contention, the defendant has stated that the last time the plaintiff visited the child was in the month of Ramadan, and the last time he gave maintenance was also in that month. After that, there was no maintenance had been given by the plaintiff towards the child. Feeling unsatisfied of cannot visiting his own child for a period of more than 3 months, as the plaintiff alleged, the plaintiff then started his Sharia civil summons against the defendant in order to demand or to claim the custody of the child permanently handed over jointly to the plaintiff and the defendant. Okay, I believe that is all for the facts of the case. Then we shall continue the presentation with the arising issues raised by the plaintiff before the Sharia High Court, inshallah. Thank you for listening. Over to you, Husna, for the arising issue.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Husna binti Zaini and my matric number is 1181828. So good morning to everyone. Today I'll be presenting to you the issues to the case that we are discussing right now, which is in regards with Hadhanah. So the first issue is whether the defendant is disqualified as Hadhanah. The defendant in this case is the mother of the child, and the Hadhanah means the guardian to the child. Okay. So the second issue is whether it is appropriate for the child to be cared by the defendant or the mother. And the third issue is whether the plaintiff's right or the husband's right to visit the child should be given by the court. So now let's move to the next part. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Amira binti Nasir. My matric number 1181827. Okay, I will present on the judgment and applied principles. For the judgment of the case, in this case, the court dismissed the plaintiff claim. The first point is the defendant, as a mother, was not disqualified from being the guardian of the child. In this case, even though the plaintiff did not come throughout the trial, However, judging from the plaintiff's statement of claim, no issue of the defendant's eligibility as Hadhanah was disputed by the plaintiff, as there were no allegation relating to the defendant eligibility as Hadhanah. Therefore, the defendant as mother was not disqualified as the guardian of the child. For the second point is, the court states that the welfare of the child needed to be considered. The welfare to be taken care of is by not exchanging guardian, as it will affect the mentality and emotion of the child who has lived with the defendant for a long time. And also, as the plaintiff was a Nigerian citizen and he only relied on a visa to stay in Malaysia, therefore the court held that it was better and appropriate for the child to be taken care by the defendant, which is the mother. For the last point, the court held that the plaintiff has the right to visit the child. The plaintiff right as a father to visit the child shall be given in order to maintain the bond of silaturahim or friendship between the father and the child. That's for the judgment of the case. Now we'll continue with the applied principles. For the applied principle, I divided into two parts, which are substantive law and procedural law. Okay, for the substantive law, this case refers to Islamic Family Law Enactment Selangor 2003. In section 82, it provides that the mother shall be of all persons the best entitled to the custody of her infant children during the conjugal relationship as well as after its dissolution, which is the divorce. Next, the court referred to section 84, which provides how the right of Hadhanah of a woman is lost. In this section, it states that the right of Hadhanah of a woman is lost if by her marriage with a person not related to the child within the prohibited degrees, if her custody in such case will affect the welfare of the child, but her right to custody will revert if the marriage is divorced, or it will lose his right of Hadhanah if by her gross and open immorality, or by her changing her residence, or being a murtad, or by her neglect of or cruelty to the child. As for the procedural law, we refer to section 61, subsection 3B3 of Administration of the Religions of State of Selangor Enactment 2003, which it provides that the Syariah High Court shall, in its civil jurisdiction, hear and determine all actions and proceedings if all the parties to the actions or proceeding are Muslim, and the actions or proceeding related to the maintenance of dependence, legitimacy, guardianship, or custody of infants. For the mode of commencement, we can refer to section 7, subsection 1 of Syariah Court Civil Procedure, State of Selangor, Enactment 2003, where it states that every civil proceeding in a court shall be begun by summons. Every summon, it can be made through Form MS2 and be occupied by a statement of claim as stated in section 8 of the same Act. I think that's all for the judgment and applied principles. I will pass the floor to my friend Sabrina for the commentary. Thank you.
Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to Mami and all my fellow friends. So my name is Nur Sabrina binti Ramli, metric number 1181826. So now I will continue on commentary of this case. So for commentary of this case, we agree with the decision of the court in this case, whereby the court dismiss the claim by the plaintiff and gives the right of custody to the defendant. We agree with the decision of this court based on the ground that the court referred to Section 82, subsection 1, subject to Section 83 of Islamic Family Law, State of Selangor, Enactment 2003, which state that the mother is the most entitled of all persons to take care of the child before or after her marriage. The court also referred to the case of Farida Hani binti Omar and Abdul Latif Ash'ari, 2006, whereby the court gives the right of Hadhanah to the mother as the mother is competent to take care of the child. And furthermore, in this case, the mother had fulfilled all the requirements to be a hadinah according to Hukum Syariah and the law. The defendant in this case, which is the father of the child, did not prove to the court that the plaintiff is not competent to take care of the child. So the right of custody had been given to the mother. Next, the court in this case also referred to Kifayah al-Akhyar, Juzuk 2, page 93, which state that Hadhanah is a power that gives the right of custody to women because women are more suitable to take care of the child and they are more compassionate, patient, and can give the best education to their child. Nevertheless, the father still has the responsibility to provide the maintenance for his children. Thus, in the present case at hand, even though the mother had been given the right of Hadhanah to take care of her child, the father's right to visit his child that is within the court order could not be denied. So that's all for commentary. I hope you guys can understand our presentation well. That's all. Assalamualaikum warahmatullahi wabarakatuh.